Under iGov, the process will be streamlined while ensuring appropriate safeguards remain in place.
And that brings to a close questions for oral answer today. I call on, point of order, the Honourable Trevor Mallard.
Mr Speaker, I think you have another matter to deal with, unless you're just going to call Mr Parker straight away.
Order. I thank the Honourable Member for his intervention, because indeed I should consider this before I call the Government Order of the Day for the address and reply. What has been lodged and indeed letters seeking Understanding Order 386 seeking an urgent debate on matters can be lodged up till, ideally they're lodged before the House sits, but I'm not in any way turning this down because that wasn't the case, because it would be, by understanding, it may not have even been possible to achieve that. But what I'm faced with here, and it's not often the Speaker has to make a decision on one of these on the hoof, but the issue, the letter from the Honourable David Parker seeks Understanding Order 386 that I allow an urgent debate on the decision of the High Court in Wellington that, quote, the Minister's consent in the overseas investment to be made by Milk New Zealand and the Crayfer Farms is set aside, close quote. Now, I feel able to make a ruling on this pretty much on the hoof, because for an urgent debate on an issue, the issue must be an issue for which a minister has direct responsibility. And a minister does not have direct responsibility for a decision of the court. That is not a matter the minister has direct responsibility for. And I believe on those grounds it's not appropriate for me to allow that urgent debate. So I'm making it very clear I'm not turning it down on the basis of the slightly unusual arrival of the application. I accept the application is perfectly in order, but ministers are not responsible for decisions of the court, and urgent debates can only be allowed, or the business of the House can only be set aside under Standing Order 386 on matters that are the responsibility of ministers. Point of order, the Honourable Trevor Mallard.
Mr Speaker, the triggering factor that makes it urgent is certainly the decision of the High Court. But it was a decision of the High Court to overturn a ministerial decision. And so what this does is undo a ministerial decision and leave a void where that decision was. Now, Sue, there might, if I were you, I might turn it down on the fact that there's a address and reply going on, and possibly an ability to deal with it there, or the fact that it can be subject of later debate. But, Mr Speaker, I'm pretty sure if we go back through some of the precedents, it's not the timing around the original decision, it's when it comes to light and becomes urgent. And that, I understand, happened at some stage this morning, but was then reported. And the other, can I make one other point, and that is that, as Mr Parker has just pointed out to me, that unless another amendment is moved, and it would be an interesting confidence amendment, that he cannot speak on it, because of course he spoke yesterday in the address and reply, as have some others.
I'll hear the Honourable Leader of the House.
Mr Speaker, I think if you were to accept that argument from Mr Mallard, there would be numerous occasions where ministerial decisions are revisited one way or another, and perhaps sometimes many, many years after the event first occurred. So I think you are quite right in saying that the provisions for an urgent debate in this House are for occasions where a minister makes a decision that has very significant public interest, and where there has been no other occasion for the House to discuss the matter. Now, this matter has been the matter of questions in the House. It's been the matter of various bits of speculation in address and reply speeches. And of course, as Mr Mallard points out, we're still in the address and reply debate. So, Mr Speaker, I think you are quite correct in maintaining the long-held sort of view or precedent that is reflected in the standing orders. It says it has to be a recent decision by the government, by a minister effectively, for which there's been no other opportunity or not likely to be any other opportunity for debate. And further, sir, I'd point out that while you're saying that you don't have to have it in on that time, the standing orders does say 1 hour before the House commences, and this decision technically was available in that time space.
I don't really need to hear a lot more, but I'll hear first the Right Honourable Winston Peters.
Mr Speaker, just as a suggestion, there's a precedent for such a ruling, and that is the injunction against, you remember, the All Black tour to South Africa, where the ruling was given by the judge favouring the injunction, whereupon that triggered an urgent debate in Parliament. So there is precedent for, I'm not trying to gainsay your decision, but there is precedent where that exactly is what happened.
First, Dr. Russell-Moore.
Thank you, Mr Speaker. Just very briefly, I would argue that rather than looking backwards, as the members over here have suggested, it's actually a question of ministerial responsibility, and what the courts have said is that the ministers must redo the decision. And that is the ministerial responsibility, which is the standing orders. That's the specific language that's used in standing orders. And there is now ministerial responsibility to reconsider the decision. That's what the courts have directed them to do.
Very briefly, I'll hear the Honourable Trevor.
And while I hesitate to disagree with the Right Honourable Winston Peters, I think he might have had his argument was slightly upside down. My memory is that the House declined the debate on the injunction when it was granted, and the reason that it was declined was that it was an injunction between a group of individuals and the rugby union for which there was no ministerial responsibility. But sir, in this case, I don't think we could have anything that was more involved with ministerial responsibility. I think if you look at the accompanying documents and go through them, there is line after line where the court has pointed out ministerial responsibility in a way that appears not to have been exercised properly. And that, sir, I think, when you have a court finding that ministers are not doing their job according to the law, then...
No, I think we've heard sufficient on this. I do not need to hear further on this. I accept the point the Honourable David Parker actually made there. It is his application. I will hear him on it.
Thank you, Mr Speaker. There are 3 parts to the test laid out in Standing Order 386. The first is that it's a particular case of recent occurrence. This clearly is. The second is that it involves the administrative or ministerial responsibility of the government. And with respect to the Speaker's initial comments, I think with respect that it does, and that the difference between the case of the rugby union that was referred to is that wasn't a case of ministerial responsibility. So in my submission, sir, the decision for you is whether this requires the immediate attention of the House, because the first 2 legs of the test are made out.
Order. I've listened to I thank the members for their contribution, because this is an important issue of order, and I appreciate the contributions. As the Honourable Trevor Mallard pointed out, in fact, the application way back in, when was it, 1985, was it? 1985 indeed. That application was turned down, and on the grounds that the Honourable Trevor Mallard has mentioned. The reason why I'm declining this application is that the case is not made for an urgent debate on a government. This is not a recent government decision or action. This is what has triggered this is the decision of a court, and that is what the application is based on. The application is specifically to debate the decision of the High Court, and no minister is responsible for the decision of the High Court. Now, What I'm not ruling is that the issue is not important and that it's not possible to frame an application that might meet the standing orders, but it's my view that this application does not meet the requirement of the standing orders, because this application is to set aside the business of the House to debate the decision of the High Court. Now, that is not a responsibility of a minister, and that's why I believe we've got to be very careful not to allow urgent debate, or setting aside the business of the House on actions that are not the responsibility of either government or of a minister. And this one is not. The application is based on the decision of the court. But it does not rule out further applications. What I'm saying is the application in front of me, in my view, does not meet the test. Just because an application has been made today doesn't mean to say it's not possible to make further applications. Members may recollect, in fact, that there was an issue in the last term where I finally did consider an application met the test. It might have been the third application on a particular issue. So this does not rule out future applications. It's just, in my view today, I have to be careful. And this particular application, I'm not in any way belittling the issue. It's just the way this application is made does not meet the test, because we cannot set aside the business of the House to debate a decision of the High Court. And on that basis, I must decline this application. Point of order, the Honourable Trevor Mallard.
I seek the leave of the House to set aside time for such a debate.
Leave is sought for that course of action. Is there any objection? There is objection. I call on Government Order of the Day for the address and reply debate.
Adjourned debate on the motion for an address and reply.